because it is being conducted and presented over Zoom and live streamed on the court's YouTube channel, the court announces that an order or issues the order that prohibits any and all persons from recording or attempting to record this proceeding by any means, whether you're using the Zoom record or YouTube record function. That is prohibited. Any other method of recording, whether it's by photograph or any other electronic measure, is also prohibited. This prohibition does not apply to the official court reporter, who of course is transcribing and reporting this proceeding just like he would do if we were in a live in-person court hearing. With all of that said, for purposes of arraignment in cause number 10,864, styled the state of Texas versus Gabriel Lee Villanueva, what says the state?
The state's ready, Your Honor.
And defense? I'm sorry, Mr. Villanueva, are you ready to proceed?
Yes, sir.
And are you in fact Gabriel Lee Villanueva?
Yes, sir.
Mr. Villanueva, an indictment has been returned into this court. Have you received a copy of the indictment?
Yes, sir.
And have you had that for at least 2 days?
Yes, sir.
In the indictment, is your name spelled correctly?
Yes, sir.
And is Gabriel Lee Villanueva your true and correct name?
Yes, sir, it is.
Now, you have the right to have someone read this indictment out loud to you here in this court session. Do you wish to have someone read the indictment out loud to you?
Yes, sir, I do.
All right, sir. Mr. Smith, would you read the indictment?
Yes, Your Honor. State of Texas versus Gabriel Lee Villanueva, charge arson, a state jail felony. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January-June term AD 2021 of the 132nd Judicial District Court for said county, upon their oaths present in and to the court that Gabriel Lee Villanueva, on or about the 5th day of July 2020, and before the presentment of this indictment in said county and state, did then and there intentionally cause an explosion by igniting a firework, and in doing so, the defendant recklessly damaged a building belonging to Raul Garcia by placing the ignited firework on the porch of the residence of Raul Garcia, against the peace and dignity of the state, signed by the foreman of the grand jury.
All right, Mr. Villanueva, you have heard the reading of the indictment. Do you understand that indictment charges you?
Chris.Oliver at whatever.
Chris, you need to mute. All right, Mr. Villanueva, I'm sorry for that interruption.
Yes, sir.
You've heard the reading of the indictment. The indictment charges you with a state jail felony offense of arson. The range of penalties for a state jail felony runs from 180 days up to 2 years in a state jail. And it also carries with it the possibility that a fine could be imposed, and if imposed, in an amount not to exceed $10,000. You understand that's the possible range of penalties that exists for a state jail felony?
Yes, sir, I do.
Then, understanding the charge, having had the indictment read to you, and understanding the range of penalties as we've just expressed it, as just gone over it, to the charge of arson as alleged in that indictment, how do you wish to plead? Guilty or not guilty?
Not guilty.
Mr. Villanueva, do you have an attorney representing you?
I'm in the process of hiring one right now, sir. Mr. P. Green.
All right.
Yes, sir.
How long do you think that process will take?
I should know something by the end of this week, by tomorrow or Saturday.
Do you anticipate being able to bond out on this charge while your case is pending?
Yes, I would, but, right now, I have a parole hold on me.
I got you. All
Yes.
right.
Yes.
Do you have somebody assisting you in employing the attorney?
Yes, sir.
Is somebody going to his office? Somebody going to take him the monies? That sort of thing.
Yes, sir.
Okay, very good. That actually almost concludes. We have one other thing left, your arraignment. The other thing that's left is there is a document that is entitled Acknowledgement of Arraignment. I believe it should have been left with you there at the table by the computer. You may certainly are either that or the bailiff is handing it to you right now. You may put your glasses on if you need to.
Yes, sir, because I cannot see with them without them. All right. Kevin, can I have the light turned on? Judge,
Yes, sir.
is it okay if the deputy turns the light on for me?
It is okay. I realize it's dark and then you have dark glasses. Let me tell you that that document entitled Acknowledgement of Arraignment is supposed to say what we have already talked about. I want you to read it to make sure that you're satisfied that that's what it says. And then in the bottom left-hand part of that document, there's a place for you to circle your plea. You plead not guilty. There's a place to say not guilty. Just circle the not guilty. And if that document says just what we've talked about and you're satisfied that's all it says, then circle your plea of not guilty and sign the paper.
Yes, sir.
If you have any question about it, just let me know.
Okay.
Yes, go ahead and turn the light on. Thank you.
Okay.
Let me see the bottom. Do we circle the plea? Okay, thank you. Mr. Villanueva, do you have any questions about that document you just signed?
No, sir. No.
And I just want to confirm, we keep the overhead lights off in that Zoom room most of the time because it interferes with the camera's
Yes, sir.
picture.
I understand.
But I just want the record to know that you needed your prescription glasses to read the document, but your prescription glasses are sort of like sunglasses. Is that correct?
Yes, sir.
And thus, I had asked you to take them off so I could see you, but you
Yes, sir.
could put them on to read,
Yes.
which you did. Is that right?
Yes, sir.
But when you put them on to read with the dimmer light and the darker glasses, it was hard to read. Is that correct?
Yes, sir.
And thus we turned the overhead lights on. Were you then able to read
Yes,
with and use your prescription glasses?
yes.
All right, sir. That concludes our arraignment this morning. Do you have any questions?
Yes, sir. On the indictment, the foreman of the jury has the same last name as the victim. And I want to see if I can set a motion to set aside the indictment because of that. 'Cause I don't know if they're related. I don't know if they're related or not.
I understand what you're saying. That's something that you and your attorney can take up.
All right.
I do not know if they're related, but that's something that you and your attorney can take up.
I just wanted to bring it to your attention.
It's a valid point, and that's something I know that your lawyer will look into. And if that's the case, if that happened to be the case, then there are some remedies for that.
Yes, sir.
All right, sir. Any other questions?
No, no, sir. I don't.
All right, sir. Thank you, sir. You may be excused.
Thank you. Have a nice day.
You too.
Judge, did you want to go right down the list or?
Yeah, that's fine with me. And turn the lights back off.
Oh, the next one. Moses Campa, he hasn't been arrested.
Correct.
Shown up here.
That's my understanding. So the next one I have is Judy Gale Askell.
She's here.
Okay. How do you think it's pronounced?
I think you said it right. But you don't say the C very good.
Jody. Good morning. Are you Jody Gale? How do you pronounce your last name? Askell? All right. Ms. Askell, we are about to conduct an arraignment in your case. I will call your case. I will make an announcement about how we are conducting the hearing since we're doing it by Zoom. And then we will take care of your arraignment. So I call cause number 10,866 for the case style, the state of Texas versus Jody Gale Askell. This is an arraignment hearing. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. We are also live streaming this case on the court's YouTube channel. We are handling the case remotely in the manner I just described in order to comply with Texas Supreme Court orders and rules and directives from the Office of Court Administration. And as such, I further order that all persons are prohibited from recording this proceeding, whether using the Zoom record function or the YouTube record function, or any other function that would attempt to record or capture electronically or otherwise this proceeding. That prohibition has one exception. That exception applies to the court reporter who is making a transcription or recording, if you will, of this hearing, just like he would do if we were in person in court, in the courtroom itself. Now, with those comments and orders being stated on the record for purposes of the arraignment, is the state ready?
State's ready, Your Honor.
And again, for the record, are you Jody Gale Askell?
Yes, sir.
Ms. Askell, the court's record indicates that you are out on bond on this charge. Is that correct?
Yes, sir.
So let me tell you that you have the right to have someone read the indictment to you. Have you received a copy of the indictment itself?
No, sir.
That you probably have. It would be the yellow sheet of paper when you were arrested and taken into the jail. You don't remember seeing that?
Yes, sir.
The indictment alleges a state jail felony offense of possession of a controlled substance, namely methamphetamine. You have the right to have someone read this indictment out loud to you. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that it charges you with possession of a controlled substance in an amount that would make it a state jail felony?
Yes, sir.
In the indictment, your name is spelled Jodi for the first name, Gale for the middle name, and Ascol for your last name. Is your name spelled correctly in the indictment?
Yes, sir.
And is Jody Gale Askell your true and correct name?
Yes, sir.
Ms. Askell, in the indictment, it is charging a state jail felony. The range of penalties for a state jail felony runs from 180 days up to 2 years in state jail. And a state jail carries the possibility that a fine could be imposed, if imposed, to be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face under this indictment?
Yes, sir.
Then understanding the charge and understanding the range of penalties that you face for this charge, to this charge, how do you wish to plead? Guilty or not guilty?
Not guilty.
Do you have an attorney representing you in this matter?
No, sir.
Are you planning to and preparing to hire your own lawyer?
I do not have the funds.
All right. And so under that circumstance, do you wish to ask for a court-appointed attorney?
Yes, sir.
Have you filled out an application for a court-appointed attorney so far?
I do not think so.
All right. Here's what I think we will do to assist you in being able to do that. In just a bit, we're going to give you a form that is a request for court-appointed attorney. It says something about affidavit of indigence and request for court-appointed attorney. That form asks for personal information such as your name and your address and your phone number and social security number, things of that nature. But it also asks for your financial information. And that I kind of extend that to include where you work, if you work, how much are you paid, that sort of information. And then how much do you receive in pay each month? How much do you spend each month on a regular basis? If you are in fact indigent and truly do not have the funds, then to hire an attorney, I will appoint an attorney to represent you. Let me pause for just a moment to ask somebody a question. So we're off the record for just a moment. All right, we're back on the record in cause number 10,866, style the state of Texas versus Jody Gale Askell. For the record, the state's attorney is still present. Defendant and defendant's attorney. There is no attorney yet. Defendant is also present. Ms. Askell, since you are out on bond, here's what I'm going to direct you to do. In order to complete your request for court-appointed attorney this morning, I'm going to direct you, order you to leave the law enforcement center and come to the courthouse. And we have a room set up where nobody else will be. You won't be you'll be social distanced from everybody. And a notary will assist you in making sure you know which questions to answer. You're supposed to answer all the questions, but sometimes people say, well, I didn't know I was supposed to answer that question. The notary will help you make sure you answer all the questions, and then we'll take your answers or we'll swear you to the truthfulness of your answers. If you are entitled to a court-appointed attorney, I will tell you right then while you're at the courthouse who that attorney is, and give you information on how to get in touch with that attorney. You also will be required to report to the adult probation office for bond supervision. And I do not know, you will pay a bond supervision fee of $50 per month, and you will pay another fee that will be applied towards reimbursing the county for the cost of the attorney. I don't know how much that will be because I haven't seen your application form yet. But I will go over all of that with you again once you are here to fill out the form. We have a room where we have a laptop computer, and sort of like there is there at the law enforcement center. And you will appear and visit with me again over this type of Zoom hearing. And I will go over that with you at that time and give you further instructions at that time. There is also another document that I think the bailiff is about to hand to you that's entitled Acknowledgement of Arraignment. It is supposed to say, it's designed to say what we have already discussed, except for the discussion about court-appointed attorney. I will ask you to look at it, to read it, to satisfy yourself that it only says what we have been discussing, and then sign it. Circle your plea of not guilty. There's a place in the bottom, the last line, the last sentence tells you to, or asks you what your plea is, guilty or not guilty. You said you plead not guilty, which is absolutely fine. Just circle the not guilty and then sign the paper. If you're not sure what it says, ask me your question before signing it. All right? The bailiff is handing you that paper right now.
Circle it.
Yeah.
Yeah.
Yes, sir. Ms. Askell, did you have any questions about that document?
Yes, sir.
All right. Do you understand that you're supposed to come to the courthouse to the 4th floor and
Fill out my attorney paper.
fill out your request for an attorney? Don't start filling it out until the notary public is there with you.
Yes, sir.
All right. I will see you in a few minutes at the courthouse.
All right, thank you.
Thank you. You may be excused to that purpose.
Next one, Mr. Schindler, he showed up and turned himself in at 8:05 this morning. I served him with the indictment.
Okay, is he there?
Yes.
Go ahead and bring him in. Taylor, while we're waiting for him to step in, can you step in here?
Yes, sir.
Mr. Schindler, I'll be with you in just a moment. Mr. Schindler, we are about to conduct an arraignment in your case. Let me put the files in order. Let me call your case and I'll make some announcements and then I'll ask for everybody's announcement as to whether they're ready or not. I call cause number 10,867 for the case styled the state of Texas versus Brock Allen Schindler. This is an arraignment in the case. The arraignment hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. It is also being live streamed on the court's YouTube channel. In order to comply with Texas Supreme Court orders and rules and directives from the Office of Court Administration. Since we are conducting this hearing in using those electronic means, I also announce that all persons are expressly prohibited from recording or attempting to record this proceeding or any portion of it by any electronic means, whether that is the record function of the Zoom hearing itself or the record function of the YouTube live streaming, or whether it's by photographic efforts or any other method that would capture or record this proceeding. All persons are prohibited from doing anything that would do that. One exception applies, and the only exception applies to the court's official court reporter who is exempt from that order because he is directed by me to make a recording of this hearing just like he would do if we were in fact in court in person. All right, with that pronouncement or those pronouncements being stated on the record, for the purposes of the arraignment, what says the state?
State's ready, Your Honor.
And Mr. Schindler, are you Brock Allen Schindler?
Yes, sir.
We are here to conduct an arraignment. I am informed that you turned yourself into the law enforcement center this morning. You were served with, someone handed you a copy of the indictment itself and told you, I don't know if they told you, but there's a provision to make a bond. Under Texas law, you have the right to have a minimum of 2 days notice of the charges or the allegations in that indictment. Since you received a copy this morning, obviously you have not had 2 days notice. And so we need to do one of two things: either reschedule you for another time after you have had 2 days notice, which will require you to come back to the law enforcement center, or if restrictions have been lifted by then, which I don't think they will be, you could come to the courthouse. But for right now, if you come back, you'll come back to the law enforcement center. That's what, and then we'll do the arraignment. Another possibility is if you wish to waive the 2-day notice and go ahead and proceed with the arraignment this morning, well, we can do that as well. But that's your choice. So what do you wish to do? Do you wish to waive the 2-day notice and go ahead and do the arraignment now? Or do you wish to reschedule and come back after you've had at least 2 days notice?
I'd like to do it now. The sooner I get back to work, the better, Your Honor.
All right, sir. And that's your request?
Thank you.
That's fine with me. Then we'll proceed. In an arraignment, the person charged by indictment has the right to have the indictment read out loud to him. And so I ask you, do you wish to have someone read the indictment out loud to you?
You have to, Your Honor.
Thank you, but I need you to tell me what you wish. Do you wish to waive that and say it's not necessary, or
It's not
yes?
necessary, Your Honor.
All right, sir. Then let me ask you just to make sure that I am sure that you are aware. Do you know that indictment charges you with a state jail felony offense of taking wildlife resource without landowner consent? Do you know that's what the charge says?
Yes, Your Honor.
In the indictment you received a copy of this morning, is your name spelled correctly?
Yes, Your Honor.
And is Brock Allen Schindler your true and correct name?
Yes, Your Honor.
Mr. Schindler, I've mentioned a couple of times that this charge alleges a state jail felony. The range of penalties for a state jail felony runs from 180 days up to 2 years in state jail. And there is a possibility as well that a fine could be imposed, if imposed, to be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face for this charge if you were to be convicted of this charge?
Yes, Your Honor.
Then understanding the charge, the charge itself, and the range of penalties, which we've just gone over, to that charge of taking wildlife resource without landowner consent, how do you wish to plead to that charge, guilty or not guilty?
Not guilty, Your Honor.
Do you have an attorney representing you in this case?
I will within a week or two. I will have an attorney hired.
All right, so you plan to employ or hire your own attorney?
Yes, Your Honor.
And when do you think that will be accomplished?
Within 2 weeks, Your Honor.
All right, so do you know at this point in time who that attorney is going to be?
No, Your Honor, I do not.
Okay, that's fine. Please let your attorney know, but most attorneys will already know this, that he or she is supposed to let us know that he or she represents you, and they're to do so as soon as possible. Do you understand that?
Yes, Your Honor.
All right, so then only one thing remains for your arraignment this morning. The deputy should be handing you or have placed on the table near you a document entitled Acknowledgement of Arraignment. There it is right there. It is designed to say what we have already discussed. Please read it and satisfy yourself that that is all that it says. If so, down in the bottom left-hand part of the document, I believe it's the last sentence on the page, there's a place to note your plea, either guilty or not guilty. You pled not guilty, circle the not guilty, and then sign the document. And if you have any questions about it at all, let me know, and we'll talk about your questions or answer your questions even before you sign it.
No questions, Your Honor.
All right, sir. Have you circled your plea
Yes, Your Honor.
and have you signed it?
Yes, Your Honor.
Then that concludes your arraignment for this morning. If you would hold that document up to the screen or to the camera so I can see the bottom part of it. Very good. Thank you, sir. You can leave that there on the table. The bailiff will pick it up, or he may pick it up at this time. And you may be excused. We will see you in a month. You and your bondsman, or if you have your attorney by then, your bondsman and your attorney will get notice of this setting, and you'll be back in court for a pretrial hearing 1 month from now, or approximately 1 month from now. Thank you, sir. You may be excused.
Thank you, Your Honor.
Judge, Mr. Highfield
Yes.
is not here. The bondsman just got a hold of Miss Gonzalez and she was pulling into town. She hasn't arrived yet. I haven't served her yet.
I didn't hear that last part, Kevin.
The bondsman has contacted her and she was just pulling into town. She hasn't arrived yet, though.
Okay, when she
is here.
Okay, we can do, if she's here, she probably needs to be processed because her bond, I think, was a pre-indictment bond. So she needs to be processed with the new, and her bondsman substitute bonds. Is Connie her bondsman?
Yes. And I have the folder here while she's doing the arraignment. I can fill that out.
Okay,
Is
that's
that,
fine.
are we speaking of Gonzalez?
Yes, sir.
I'm not, my records don't indicate that she was arrested before indictment. Maybe they're wrong. Do you have the bond, Judge? I don't.
Let me see. The charge is assault of a public servant.
Right. That's right. But she didn't, she wasn't arrested that night. She went to the hospital. I believe. Yes, that's right. And I remember now. That's correct.
I don't show a bond, but it doesn't really matter. She's here, I guess.
We'll figure it out.
Okay.
I just had if she was arrested since the indictment, she's still out on bond.
Well, we'll cover that with her.
You bet.
Good morning. Are you Miss Gonzalez?
Yes, sir.
Could you move just a little bit closer to the laptop? Yes, ma'am. Thank you.
No problem.
Ms. Gonzalez, we're going to conduct an arraignment in your case. I need to call your case and make an announcement on the record, and then I will talk directly with you. So let's begin. I call cause number 10,869 for the case style, the state of Texas versus Erica Marie Gonzalez. This is an arraignment hearing. For the record, this hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This hearing is also being live streamed on the court's YouTube channel in order to, both of those presentations are being done in order to comply with Texas Supreme Court rules, orders, and rules and directives from the Office of Court Administration. Because the hearing is being presented in this fashion, I expressly prohibit any and all persons from recording any portion of this proceeding, whether using the record function of Zoom or YouTube, or by recording in any other manner, such as taking a screenshot of the proceeding. There is an exception for the official court reporter who is in fact recording this proceeding just like he would do if we were in person in court. With that prohibition being discussed on the record for purposes of arraignment, what says the state?
Ready, Your Honor.
And then, are you Erica Marie Gonzalez?
Yes, sir.
Ms. Gonzalez, an indictment has been returned into this court charging you with assault of a public servant, which is a third-degree felony as charged. Have you received a copy of the indictment in this case?
Not yet. I found out on Monday, but I got here today from Arlington. But I haven't got paperwork yet.
All right. Now, you're being handed a copy of the indictment right now. That is, yes, ma'am, that yellow sheet of paper. That is, it has officially been served on you now.
Yes, sir.
And so let me talk to you. That means there are a couple of other matters that I need to talk to you about. The first one is you have the absolute right to have a minimum of 2 days notice of the charges that are spelled out in that yellow sheet of paper, that copy of your indictment that you have.
Yes, sir.
Obviously, you have not had 2 days notice because I saw you just now receive it. So that means we do one of two things. One, we just reschedule your hearing and you come back after 2 days, whether it's exactly 2 days or whether it's a week. We would reschedule you so you would have at least 2 days notice. Another possibility is, but it will be your choice. Another possibility is you can waive or give up the 2 days notice and instead go ahead and have the arraignment this morning while you're already here. But as I said, pardon?
Sorry, I said, may we please?
Say that again.
I said, may we please?
May we please do what?
Have it today.
Okay. So is that your preference?
Yes, sir. I live in Arlington. I just want to make sure don't miss this.
Yes, ma'am. And I appreciate that. And since it is your choice and your choice is to go ahead and do the arraignment this morning, I will grant you your request and we will do the arraignment this morning. So let's do so. In an arraignment, you have the right to have someone read that piece of paper out loud to you here in court. Do you wish to have someone read that indictment to you?
No, sir.
Do you understand that that indictment charges you with a third-degree felony charge of assault of public servant?
Yes, sir.
In that indictment, is your name spelled correctly?
Yes, sir.
And is Erica Marie Gonzalez your true and correct name?
Yes, sir.
Ms. Gonzalez, I've mentioned a couple of times that the indictment charges a third-degree felony. So let me tell you what the range of penalties are for a third-degree felony. A third-degree felony carries a range of penalties from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division. It also carries the possibility that a fine could be imposed. And if imposed, it would be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties that you face for a charge like that spelled out in the indictment?
Yes, sir.
Then let me ask you, to that charge, how do you wish to plead? Guilty or not guilty?
Guilty.
Do you understand you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right for it not to be used against you just because you might have exercised that right. Do you understand all that?
Yes, sir. Do we have the choice for no contest? Or?
You do. You certainly do. But if you choose that choice, ultimately it has the same effect, or it could result in the same effect as if you had pled guilty. You can change your plea later to plead no contest, or to plead guilty, or to plead not guilty. This is not the last chance to enter a plea.
Yes, sir.
So with those explanations, what plea do you want to enter? Guilty, no contest, or not guilty at this time?
Guilty.
All right. Now, do you have an attorney representing you in this case?
No, sir.
Are you in the process of hiring your own attorney?
No, sir.
Why not?
We don't have the money for one.
Okay. So would you like to ask for a court-appointed attorney?
Yes, sir.
Then I will give you that opportunity to do so this morning. And if you are in fact entitled to a court-appointed attorney, I will let you know this morning who that attorney is. But you have to fill out a form, which we will require you to swear to the truthfulness of it, of the information in the answers to the form questions. That document is entitled that document is entitled Affidavit of Indigence and Request for Court-Appointed Attorney. I'm going to direct you, if you are going to post bond, do you anticipate your bondsman making arrangements for you to go ahead and be out on bond even this morning?
Yes, sir.
Once that's accomplished, I'm directing you to come over to the courthouse from the law enforcement center. Do you know where the courthouse here is here in Snyder?
Yes, sir.
Come to the 4th floor. We have a room we set up with a laptop that will be set up to do another hearing, not a hearing, another face-to-face without us being physically present with one another. And you will fill out that form here in that room. We will provide you the form. The deputy sheriff may provide you with that form, but don't fill it out till you get here.
Yes, sir.
Now, before you leave where you are right now, the deputy is about to hand to you another document that is entitled Acknowledgement of Arraignment. It is designed to say what you and I have already been talking about.
Yes, sir.
Read it, make sure you're satisfied that that's all it says. If so, there's a place on the bottom left-hand part of the document, I think it's on the last line, for you to circle your plea, guilty or not guilty. Once you do that, then sign your name. But if you have a question about that document or what it's saying, ask me your question even before you sign it, and I will discuss that with you before you sign it. All
Yes,
right?
sir.
Okay, the deputy will bring that paper to you in just a moment.
one.
Oh. This one.
Yes, ma'am.
Oh,
Read
sign
it.
Oh, sorry.
Sign, if it says what we've already discussed, then you can sign it, circle your plea.
Okay.
All right, let me see the paper. Hold it up to the camera so I see your signature and a little closer. Turn it to your left. No, the other way. A little further. I want to see if you circled your plea.
Oh, no. Oh, okay. There we go.
Okay, thank you. It's not in the same place it used to be. All right, I'm gonna have to change the way I speak about it. Do you have any questions about that document that you just signed?
No, sir.
All right, then that concludes your arraignment, but you need to come to you have to come. I'm ordering you as a part of your bond to come to the courthouse to the 4th floor. Let us know that you are here. Yes, you bring that with you. And the notary will give you some information about how to fill that form out. And then he will swear you to the truthfulness of your answers. Once that's completed, and it shouldn't take but a few minutes, once that's completed, we will then direct you across the street to the probation office. And there the probation office will talk to you about bond supervision because you will report for bond supervision. And I will tell you about that when you fill out that form. I got to see what that form says. But once it's filled out, I will tell you more about reporting to the probation office. And that will also take just a few minutes, and then you'll be through for the day, and we won't, you won't have to come back for anything for another month at least.
Okay. Yes,
All right.
sir.
Do you have any questions?
No, sir.
All right, then you can go take care of your things that you need to take care of, and then bring that paper, the request for a court-appointed attorney, bring that with you when you come to the courthouse.
Yes, sir. Thank
4th
you.
floor. Yes, ma'am. Are you Mr. Beard?
Yes, sir.
Is that how you pronounce your last name?
Yes, sir.
All right. Mr. Beard, we are about to conduct an arraignment. I need to call your case, make a couple of pronouncements, and then begin, and I will talk directly with you at that time.
All right.
All right, I call cause number 10,870 for the case style, the state of Texas versus James D'Anthony Beard. This case is called for purposes of arraignment. This arraignment hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. We are also live streaming this hearing on the court's YouTube channel. These presentations of this hearing are being accomplished in order to comply with orders of the Texas Supreme Court and rules and directives from the Office of Court Administration. Because the hearing is being presented in the fashion described, I further announce that any and all persons are expressly prohibited from recording any portion of this proceeding by any means whatsoever, whether it is the record function of Zoom or YouTube, or whether it's a screenshot or any other photographic or electronic attempt or effort to record this proceeding. Those are all prohibited because the one exception applies to the court reporter for this court, who is in fact recording this proceeding, just like he would do if we were in person in the courtroom itself. Those pronouncements being made, let's do this arraignment. For purposes of the arraignment, is the state ready to proceed?
State's ready, Your Honor.
And for the record, are you James D'Anthony Beard?
Yes, sir.
Mr. Beard, have you received an indictment, a copy of the indictment in this case?
Yes, sir.
And and are you out on bond at this time?
Oh, yeah, I plan on buying now.
Okay, so you're in the process of bonding out.
Yes, sir.
When did you receive your copy of the indictment?
Yesterday.
All right, the law says you have the right to have a minimum of 2 days' notice of the charges. If you just got your copy yesterday, you have not had the 2 days' notice. And so that sets up another piece of information I need to go over with you. Since you have the right to have a minimum of 2 days' notice, we will do one of two things. We will either reschedule your case for arraignment and give you the 2 days and then bring you back to the law enforcement center for the arraignment itself. That's one possibility. The other possibility is, if you choose, if you wish, you can waive the 2 days notice and instead ask to go ahead and have your process, your arraignment completed today while we are here. But that is your choice. So let me ask you, what do you want to do? What is your choice?
I'm good with completing it today.
Please tell me that again.
I'm good with completing it today.
Oh,
Still
you're
want
good
to
with completing it today. Is that your choice? Is that what you want to do?
Yes, sir.
All right, sir. Then I will grant your request to proceed today, and I will do so. Let me begin by telling you that in an arraignment, you have the right to have someone read the indictment out loud to you. Do you wish to have someone read the indictment out loud to you?
No, sir. I already read it.
All right, sir. And do you understand that the indictment alleges a third-degree felony offense of intoxication assault?
Yes, sir.
In the indictment that you received a copy of yesterday, is your name spelled correctly?
Yes, sir.
And is James D'Anthony Beard, B-E-A-I-R-D, your true and correct name?
Yes, sir.
Mr. Beard, as I have mentioned, the indictment alleges a third-degree felony charge. The range of penalties for a third-degree felony run from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice. The range of penalties also includes the possibility that a fine could be imposed, and if it were to be imposed, to be in an amount not to exceed $10,000. You understand that's the possible range of penalties you face for a third-degree felony charge.
Yes, sir.
Then, understanding the charge and understanding the range of penalties we have just discussed, to the charge of intoxication assault, a third-degree felony, how do you wish to plead? Guilty or not guilty?
Is there no contest I can plead?
There is. But let me tell you 2 or 3 things about your plea. First of all, a no contest plea ultimately has the same effect as a guilty plea. Secondly, you have the right to enter any plea guilty, no contest, or not guilty. And at this time, you have the right to enter any one of those pleas, and you have the right for it not to be used against you if you enter one of those pleas, including the plea of not guilty. You can change your plea at a later time, but it will be on record that you have entered one of these pleas. Do you understand those options?
Yes, sir.
Understanding them to the charge of intoxication assault, at this time, how do you wish to plead? Guilty, no contest, or not guilty?
No contest.
All right, sir. Do you have an attorney representing you?
I need a court-appointed one.
Okay, that didn't exactly answer my question, but in a roundabout way, it does. Why
No.
do you?
No.
Why do you? Okay, that answers my question. Why do you need a court-appointed attorney instead of hiring your own attorney?
I don't have the money to hire my own.
Okay, I understand that fully. Then I will give you the chance, the opportunity to formally ask for a court-appointed attorney. I require that request to be made in writing because, and I will give you the form to use to make that request, and I will give you a chance to do that today, this morning.
All right.
If you are entitled to a court-appointed attorney, I will appoint an attorney, and I will tell you this morning who that attorney is. But as I say, there's a formal way to ask it. We do it on a form that's entitled Affidavit of Indigence and Request for Court-Appointed Attorney. It has to be sworn to. The answers to those questions on that form must be sworn to. And so I will provide a notary public to take your sworn statement that those answers are true. Sometimes people have some questions about what questions they're supposed to answer. The answer is you're supposed to answer all of them, but sometimes people still aren't sure. And so the notary will assist you in knowing which ones to answer. He will not answer them for you, but he will just give you direction that, yes, this needs to be answered. If you bond out this morning, is that your plan?
Yes, sir.
Have you already made arrangements with the bondsman?
Yes, sir.
All right. Once you bond out, you are directed and ordered to come to the courthouse, to the 4th floor, where we have we call it the Zoom kiosk. We have a room where you would, with a table and a laptop, so you could sit in front of it just like you're sitting in front of that laptop, and you and I can communicate again one-on-one without having to violate any social distancing rules. Okay. And then I will, and the notary will assist you in filling that form out, not assist you. He will just answer your questions about what questions to answer, things of that nature. Then he will swear you in, and he will bring that form to me, and I will be able to examine it and tell you if you're entitled to a court-appointed attorney, and if so, who it is. You will also be required, because a condition of your bond will require you to report for bond supervision. You will also be required to go across the street after you fill out that request for court-appointed attorney and to report for bond supervision. That takes about 30, but they just sign you up is basically what they're doing.
All right.
And then I will tell you this again when I talk to you after you've filled out your form. You will be required to report for bond supervision once a month. You will pay a $50 per month bond supervision fee, and then you'll pay another amount, another fee each month to help repay back the amount that the attorneys, that the county will pay the attorney who will be assisting you. But I will talk to you about all of that when you're in front of the camera or the laptop at the fourth floor of the courthouse. Now then, before you go, the bailiff is going to hand you one more document, or a document entitled Acknowledgement of Arraignment. That document is designed to say what we have been discussing. Please look at it while you're sitting there, read it, and if you have any questions, you let me know. If you don't have any questions, I'll ask you to sign it. And there's a place at the bottom of the document for you to note your your plea, not your guilty plea, your plea. You said you wanted to plead no contest. So just right below where it says guilty, not guilty, mark through guilty, not guilty, and write in no contest.
All right.
You see that?
Yes, sir.
Okay, read that document. If you have any questions, you let me know. We'll talk about it.
All right, I understand.
All right, sir. Have you signed it?
Not yet.
Okay. Did you write in no contest or circle guilty or not guilty?
Yes, sir. I wrote in no contest.
All right, would you hold that up to the screen so I can see your signature? A little bit closer. Okay, very good. One last time, do you have any questions about that document?
No, sir.
Then you'll give that document back to the bailiff. I think he will give you the affidavit of indigence and request for court-appointed attorney. Bring that one with you to the courthouse as soon as you bond out and are released over there.
All right.
All right, sir. Thank you. You may be excused.
Judge, since that was an alcohol-related offense, will he be required to have an interlock device during bond supervision?
That's one of his bond conditions, yes.
Okay.
Are you Linda Bernal?
Yes, sir.
Let me speak to the bailiff for a second.
Yes, sir.
Has Mr. McQueen shown up over there? Do you know?
I haven't looked out front.
Just ask them if, or don't worry about it. Kayla can ask Hannah.
Yes, sir, he is. He has out front.
Okay, thank you. All right, let's do Ms. Bernal's arraignment, and then we'll do McQueen if his attorney gets on. Well, we'll do McQueen whether his attorney gets on or not, I guess. Ms. Bernal, I'm about to conduct an arraignment in your case, subject to certain conditions. Let me call your case. I will make some announcements, and then I will talk directly with you. Can you scoot just a little bit closer to the table? Thank you.
Yes, sir.
All right. I call cause number 10,872 for the case style, the state of Texas versus Linda Ibarra Bernal. This is an arraignment, and I announce that this hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This hearing is also being broadcast or live streamed on the court's YouTube channel. Both of those presentations are made in order to comply with Texas Supreme Court orders and rules and directives from the Office of Court Administration. Because the case is being presented in this fashion, I announce that any and all persons are expressly prohibited from recording this proceeding in any fashion, whether using the record function of Zoom or live stream, YouTube, or whether it's being recorded in some other fashion, be it a screenshot or a photographic capture of an image. Those are expressly prohibited. There is one exception. That exception applies to the official court reporter for this court, who is in fact recording this proceeding, just like he would do if we were in person in court, which of course we are not because we're live streaming it. With those pronouncements made, for purposes of arraignment, what says the state?
State's ready, Your Honor.
And defendant, are you Linda Ibarra Bernal?
Yes, sir.
Ms. Bernal, an indictment has been returned into this court charging you with a state jail felony offense of possession of a controlled substance. Have you received a copy of the indictment?
Yes, sir. This morning.
You got it this morning?
Yes, sir.
The law says you have the right to have at least 2 days notice of the charges in the indictment. Since you just got it this morning, then you have not had 2 days notice. So I will give you 2 days notice and we will bring you back at another date.
Can we
Or-
just today?
We can't, there is another possibility, and that would be for you to waive or give up the extra 2 days notice and ask that it be accomplished and done today.
Yes, sir.
What
I
do
would
you-
like to do that.
All right. Then I will accept your request and we will do it today. We'll do it right now. You have the right to have someone read this indictment out loud to you here in court. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that the indictment charges you with a state jail felony possession of a controlled substance, namely methamphetamine?
Yes, sir.
In the indictment that you received today, is your name spelled correctly?
Yes, sir.
And is Linda Ibarra Bernal your true and correct name? Oops, we froze. Doesn't happen very often. Ms. Bernal, I'm sorry, the screen froze on us there for a moment.
Yes, sir.
Is Linda Ibarra Bernal your true and correct name?
Yes, sir.
As I've mentioned, this offense charges a state jail felony. The range of penalties for a state jail felony runs from not less than, or it doesn't say not less, the statute says it runs from 180 days up to 2 years in state jail, and carries the possibility that a fine could be imposed, if imposed, to be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face if you were to be convicted of this charge?
Yes, sir.
All right, then knowing what the charge is and knowing the range of penalties you face if convicted of this charge, to this charge, how do you wish to plead? Guilty or not guilty?
Guilty.
Do you understand you do not have to enter a plea of guilty? You have the right to enter a plea of not guilty, and if so, it will not be used against you or held against you just because you might exercise your right. Do you understand that?
Yes.
All right. Do you have an attorney representing you?
No, sir. I want to get a court-appointed lawyer.
All right. And I see that an application has already been filled out,
Yes.
but I'm going to do a couple of things and I'll tell you a little bit more about that in just a moment.
Okay.
we're almost through with your arraignment this morning. There's one thing left. I want you to look at a document entitled Acknowledgement of Arraignment. The bailiff will hand you a copy of that document or place it there on the table.
Okay.
Is it there on the table? Oh, no, I think I can see the bailiff getting it ready for you
Yeah.
right now. All right, that's entitled Acknowledgement of Arraignment. Please look at it. It should say what we have already discussed.
Yes,
At the bottom of the document, there's a place to plead guilty or not guilty. If you would just circle your plea and sign your name, unless you have a question. And if you have a question, you let me know. We'll discuss that first.
no, we're good. Okay. Oh, sorry.
If you would hold it up to the camera and let me see the bottom, hold it up towards the top there. A little bit higher.
Oh,
That's good. Thank you, ma'am.
you're welcome.
Now then, you need to finish. Do you plan and expect to bond out this morning?
Yes, sir. I've already paid everything. I'm just waiting to get bonded.
Okay, then you need to come to the 4th floor of the courthouse.
Okay.
And I will examine the request for court-appointed attorney.
Okay,
And I will tell you if you are entitled to the appointment of an attorney. And
okay,
if so, I will tell you who it is. And I will do all of that this morning while you're here. You won't be here very long.
okay,
I will then send you across the street to the probation office because a part of your bond requires you to report for bond supervision.
yes, sir.
You will pay a $50 per month bond supervision fee. It's not due today. You will report each month between the 15th and the 20th days of each month. But I will tell you all of that again when you come to the courthouse. When you're at the courthouse, we have a room for you where we have another laptop set up, where we will talk to you again, just like we are right now over the Zoom cameras on the laptops. And
Okay.
I will give you some more instructions, but that will be all for this morning.
Okay, so as soon as I get out of here, go over there. As soon as I
Yes,
get out,
ma'am.
go straight over there. Okay,
Yes, ma'am. To the 4th
Okay.
floor of the courthouse.
okay.
All right. Any other questions?
No, sir.
Thank you, ma'am. You may be excused.
Okay, thank you.
I'm going to admit Kenny.
And Judge, Mr. McQueen has a case on the trial docket too.
Yes, if it's all right, I propose we do both of them this morning.
Right, sure.
Good morning, Mr. Maxwell.
Good morning, Your Honor. Ben,
Morning, Kenny.
Kenny, I was just telling, and I think you got in on that part of what I was telling Mr. Smith. I propose that we do Mr. McQueen's arraignment first and then take up on the new case and then take up his pretrial instead of having him come back again this afternoon.
that would be perfectly fine with us, Your Honor.
Okay. Then we're going to do the arraignment first. So let me make those pronouncements. I call cause number 10,873 for the case style, the state of Texas versus Billy Eugene McQueen. This is an arraignment hearing. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This hearing is also being live streamed on the court's YouTube channel. These presentations through these mediums are being done in this fashion in order to comply with orders from the Texas Supreme Court, as well as rules and directives from the Office of Court Administration. Because it's presented in this electronic form, the court announces that any and all persons are expressly prohibited from recording this hearing or this proceeding in any fashion, whether it's using the record function of Zoom or the record function of YouTube, or if it's any other attempt at an electronic or other recording or capturing of any portion of this proceeding that is expressly prohibited. That prohibition does not apply to the court's official court reporter, who in fact is directed to record this proceeding just like he would do if we were in court, in person in court. We are in court, just not in person. We are by this Zoom presentation. All of that now being stated, for purposes of arraignment in cause number 10,873, what says the state?
Ready, Your Honor.
And the defense, Mr. Maxwell?
Defense is ready, Your Honor.
I'm going to direct some questions to Mr. McQueen, who is present by Zoom as well. And Mr. McQueen, if you have any questions with respect to those matters I direct at you, you certainly can confer with your attorney before answering. And of course, Mr. Maxwell knows how to insert a question or an objection if that were to occur. So for the record, are you Billy Eugene McQueen?
Yes, sir.
Mr. McQueen, you are out on bond, it appears, in this cause 10,873, wherein you are charged with bail jumping and failure to appear. Is that correct, that you're out on bond?
Yes, sir. I'm on bond.
Then we'll proceed with the arraignment. You have the right to have the indictment read out loud to you here in open court. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that it charges you with a third-degree felony offense of bail jumping and failure to appear?
Yes, sir.
In the indictment, is your name spelled correctly?
Yes, sir.
And is Billy Eugene McQueen your true and correct name?
Yes, sir.
Mr. McQueen, this charge in this indictment is a third-degree felony charge. The range of penalties for a third-degree felony runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division, and it also carries the possibility that a fine could be imposed. And if it were to be imposed, it would be in an amount not to exceed $10,000. Do you understand that's the range of penalties you face for this charge?
Yes, sir.
Understanding the charge and now having discussed and understanding, telling me that you understand the range of penalties to the charge in the indictment of bail jumping and failure to appear, how do you wish to plead, guilty or not guilty?
Mr. McQueen will enter a plea of not guilty, Your Honor.
All right. All right, sir. Then, and we note that Mr. Maxwell is your attorney and is representing you and is with us here in this hearing. So that concludes the arraignment hearing with only one item or matter left. The bailiff should hand to you a document entitled Acknowledgement of Arraignment.
Okay.
I will ask you to look at it, to read it. It should say, it is designed to say what we have already discussed. Make sure you're satisfied that that's what it says. If you have any question about it at all, you ask me or your attorney, and I'll discuss it with you before you sign it. There is a place at the bottom of the document for you to note your plea. You entered a plea of not guilty, so just circle the not guilty. It's on the, basically the last full line of the document, I believe.
Okay.
And then if you're satisfied that that document says what we've discussed, then after circling your plea of not guilty, sign the document.
Yes, sir.
All right, sir, I got it signed.
Thank you. Would you hold it up to the screen? And do so a little bit closer so that we can see what it said, that it, a little bit higher now. All right, and then down at the bottom, go higher, please. And again, a little bit higher. I want to see that you've signed it and you circled the not guilty plea.
Yes, sir.
All right, one more time, a little higher.
Hi.
There you go. I can see that he signed it. Thank you, sir.
Thank you.
You'll give that back to the bailiff and he will present it to the court. That concludes your arraignment. Now we're going to take up your pretrial on the other case that is in this court. And so for pretrial purposes, I'm calling cause number 10,853, also styled the state of Texas versus Billy Eugene McQueen. This is a pretrial hearing in that case. You were previously arraigned in January on this charge. The announcements about the Zoom hearing and the live streaming and the prohibition against making any recording continue in effect for this pretrial hearing. For purposes of pretrial, what says the state?
State's ready, Your Honor.
And defense?
The defense is ready for the pretrial, Your Honor. We do have requested the court to allow us to move this case to the next docket based upon the fact that I was just retained last night, as this court's well aware.
I'm not aware. When you were retained.
Your administrator, I should say.
Okay.
And the fact that I haven't called Mr. Smith yet would indicate that I've just recently gotten on board.
Well, it would for a good lawyer like you. There are some that it wouldn't mean that.
Understand.
But I accept your representation, and we appreciate the fact that you are in the case and representing Mr. McQueen.
Thank you.
All right. Do you have any? I'm going to grant that request and remove this case from this month's docket, which will move it up. I say it, move it up. I believe there are some matters in front of it that quite probably will no longer be on the docket next month. And so it will move up in all likelihood in the court's docketing program. But we will take this up, that part up next month. Is there anything else that we need to take up in Mr. McQueen's case this morning?
No, Your Honor, just while I had this opportunity to talk to Ben face to face, Ben, or Zoom to Zoom, Ben, if you wouldn't mind, would you send me discovery on these cases?
Yes, sir. Probably get that out to you next week.
I think I've got a letter coming to you requesting it, but since we were here, I thought I'd go ahead and ask you now.
Very good.
All right.
While we have this opportunity, I might also advise, I have received unofficial reports that suggest the Supreme Court's restrictions on in-person hearings may be either lifted or not renewed. Right now, those restrictions are effective through April 1 or until April 1, I think I should say. And there is an indication that I've received even before Governor Abbott's pronouncements about lifting some restrictions, that the in-person restriction may be loosened. That may be a way of putting it. And that means we may be able to have in-person hearings. We may still have to comply with some restrictions about how we conduct those in-person hearings. But in the past, I have complied with all of the requirements to conduct in-person hearings before those were totally restricted. And I say that to say, I intend to comply with those requirements in order to hold in-person hearings going forward as soon as we are allowed to do that. I do think that that's probably going to occur by April 1. And so strong possibility our next pretrial hearing will be in early April, probably April 6th. And I anticipate, and maybe I should say hope, but I anticipate as well that we will do that in person. Anything else, Mr. Maxwell?
Does that mean the lawyers have to be in person too, Your Honor?
That's a bit over my objections, but yes, it does.
You know, I was on a little, well, can we go off the record for a moment? Or